Hello and welcome back to our second segment on the Property Practitioners Act.
One of the new sections in the Act is titled Consumer Protection. Actually, it's a chapter in the Act, and one of the sections in the Consumer Protection chapter deals with a mandatory disclosure document. I'm not exactly sure what this mandatory disclosure document is going to be, but I really do believe that it is going to be a document where the owner of the property is obliged to disclose what they know about the property so that the buyer or the tenant is able to assess what it is that they are either going to purchase or lease. Mandatory disclosure form is now to be signed by the owner at the time that the mandate is granted, rather than at the time or just before the sale is concluded. And this is obviously going to add to the admin of the agent. The form also has to be signed by both the owner and the purchaser or the tenant, and it has to be annexed to the deed of sale. If this is not done, then there are ramifications for the agent, and the agent can be held liable by a person who suffers damages as a result of this. So this mandatory disclosure form is going to be very important in the future. We don't know what this mandatory disclosure form is going to look like. This document will be published with the regulations. So as soon as the regulations come out, we'll know exactly what the mandatory disclosure form is going to say. I'm hoping it's going to be similar to the one which the Estate Agency Affairs Board are currently recommending. It might, however, have some type of warranties attached to it. I'm hoping that's not the case, because then we might find foot stewards going out the window completely. A failure to comply with the rules relating to the mandatory disclosure form will not only expose the agent to liability for damages, but it's also sanctionable conduct in terms of the Act, which means that the agent will be able to be found guilty of an offence in terms of the Act and also punished by the Property Practitioners Regulatory Authority, as well as being held liable for civil damages if someone has suffered a loss as a result of it.
So what this in effect means is that if a mandate is taken from a seller or from a landlord and the agent does not have this disclosure form, then even if a disclosure was made, orally for example, or certain defects were pointed out, by law we now have a deeming provision. The Act now says if there's no such disclosure form, basically what it's saying is even if you did actually make disclosure of certain defects, the law is going to presume that you did not. In other words, it's now going to be incumbent on an agent to ensure that this document exists. Otherwise, you could be held personally liable for any defects which are perhaps pointed out or found out at a later stage. I agree with Dion at this point. I don't know whether he actually said this, but this does not necessarily override the current foot stewards clause that we have in our contracts. In other words, where the purchaser assumes the risk when he buys property, or the tenant assumes risk when he rents property, because the buyer or tenant still has a duty to also do the necessary investigations and look and see whether the property has any defects, etc. But this document not being in existence is going to cause trouble for any agent, because I think it will make it so much easier for a purchaser then to build a case and say, but you know, there are certain defects, and had you provided me with this disclosure form, I would have known about it. Because the other thing which we have to be careful of here is that at section 69 of the Act, which is the very last sentence of this particular chapter, it says a property practitioner owes a buyer and a seller a duty of care. Not just the buyer and seller, of course, it's also the landlord and the tenant, which they owe a duty of care to, which means if you do not have this document in your possession, you are failing your duty of care. It's as simple as that, because you're not letting your tenant or your purchaser know of any potential defects that the seller might know of. And by not doing that, you as the agent are now putting yourself squarely in the firing line. So it would be highly recommendable to any agent to adhere to this particular section of the Act once it commences. At present, people seem to think that the disclosure form that the Estate Agency Affairs Board has recommended, that it's obligatory. It is not obligatory at this stage. It's not compulsory that agents use it. But the Estate Agency Affairs Board has said to agents, here's a document that we've prepared, it's there to protect you as the agent, for pretty much the same reason as what the Property Practitioners Act is going to now provide. So we are going to hopefully just see a normal continuation of conduct. I think most offers to purchase that we receive nowadays do have a disclosure form attached, so the agents I think will be quite used to this once this does become law. But we have also seen offers to purchase coming in every now and again where they don't have such a form attached. There the agents are going to be at risk So they need to be very much aware of this particular clause or this particular section in the Act. Right, so in a nutshell, what we're trying to say here is that estate agents or property practitioners, we've got to be careful, it's not just estate agents, we're so used to speaking of estate agents, property practitioners are going to have to be mindful of this section in the Act, because if they don't adhere to it, it's quite simple, they are going to be looking for trouble. Uninvited trouble. It's as simple as that. So they must adhere to this particular section in the Act.
This mandatory disclosure form section starts off placing an obligation on sellers or landlords to complete these forms to protect purchasers and tenants. But then in the second section they limit the application to a sale scenario, and they forget completely about a landlord-tenant relationship, which is just inconsistent, and I'm certain it was just an oversight on the part of the drafters.
Misprints and inconsistencies, which doesn't make it easier for us as attorneys to interpret and help agents or property practitioners to apply this legislation, because they're going to come to us for advice, and then we're going to have to give them advice based on legislation which we know is not correct. There are inconsistencies and there are blatant errors in the drafting of this piece of paper.
Amendments were merely pointing out obvious mistakes and inconsistencies, and obviously nothing was done to remedy these errors, and they've gone through right into the final Act.
And then of course in closing, when it comes to this issue of a duty of care, we have to remember what section 71 says, and I'll read it for you. It talks about penalties, and it says the following. It says, a person convicted of an offence in terms of this Act is liable to a fine or to imprisonment for a period not exceeding 10 years. So what this means, ladies and gentlemen, is quite simple. That if you breach your duty of care, you could have two things facing you. We talk about a double jeopardy situation. You could be sued for damages, you could face criminal sanction. So for this reason, I urge any property practitioner to take this particular part of the Act very, very seriously.